Good afternoon. My name is Jordan Rosen. I'm a tax director and head of estate and trust planning at Belfin Lyons and Schumann. In March of 2020, Congress passed the CARES Act, which addressed certain retirement plan changes, including the waiver of RMDs for 2020. But today I'd like to go back a few months to December of 2019 when Congress passed the SECURE Act. And this act made certain changes to IRA contributions and retirement plan distributions. Let's cover some of those aspects today. The first item I'd like to cover is the repeal of the maximum age for traditional IRA contributions. Now, prior to 2020, the old rule was that you could not make an IRA contribution once you reached age 70 and a half. Starting in 2020, however, there is no age limit for making a traditional IRA contribution, but you still have to have earned income during the year. That has not changed. So this allows individuals that have earned income and are working beyond age 70 and a half to continue making IRA contributions, and that's a good thing. One point to be made, and that's the third bullet point on this slide, is that they've now coordinated this provision with the Qualified Charitable Distribution, or the QCD rules. This is the rule that allows you to directly move funds from your IRA directly to a charity, and it would be considered as part of your required distribution, but it wouldn't have to be included in taxable income. What Congress said is that if you make a traditional IRA contribution that is deductible after age 70 and a half, to the extent of the amount of that contribution, you have to reduce the amount of QCD that is non-taxable. So you want to get with your accountant and your tax advisor if you plan on making IRA contributions beyond age 70 and a half, and also making qualified charitable distributions out of your IRA. Let me give you an example. John is age 73 and is eligible to make a $7,000 deductible IRA contribution in 2021. In 2022, he makes a QCD to his favorite charity in the amount of $10,000. Under the new rules, $7,000 of the QCD is taxable and is included in his gross income in 2022. So there is some need to coordinate if you are going to do both a QCD distribution and also make a deductible IRA contribution. The second change made by the SECURE Act deals with required minimum distribution age, and is raised from age 70 and a half to age 72. So prior to 2020, required minimum distributions had to start no later than the April 1st of the year following the year in which the account owner or plan participant turned age 70 and a half. The new law, starting in 2020, for IRA owners and plan participants who turned 70 and a half after 2019, so starting now in 2020, the required beginning date for taking your RMD is now April 1st of the year following the year that you turn age 72. So if you turned age 70 and a half prior to 2020, you're under the old rules. However, if you turn age 70 and a half beginning in year 2020, your new required minimum distribution age is age 72. So take a note, as I've mentioned here on the slide, for those that turned age 70 and a half and in 2019, but deferred taking their first year's distribution until April 1st of 2020, you're still under the old rules. Okay, now, however, to coordinate this with the CARES Act, which suspended all 2020 required distributions, you don't even have to take that April 1st, 2020 distribution. And you also want to note that only the age for taking your required minimum distribution has changed. The age for making the qualified charitable distribution, that QCD, as I discussed earlier, remains at age 70 and a half. The third area that I'd like to cover, and this is the largest section of today's discussion, deals with post-death distributions from retirement plans. And mostly this deals with inherited accounts such as inherited IRAs, inherited 401k plans, where the individuals died and left the plan assets to the beneficiary, who might be the surviving spouse or someone else. These rules have changed. So what I'd like to do is go through these in a question and answer format that I think will be very helpful for you. So the first question is, how does the Secure Act change post-death retirement distributions? The answer is, with a few exceptions, payouts must be made within 10 years of death rather than over the life expectancy of the beneficiary. If you recall, the old rule was that if you inherited an IRA or an employer plan, you were able to take the required minimum distribution over your life expectancy. But with several exceptions, as I'm going to get to in just a few moments, the Congress has done away with this stretch IRA concept, and the assets from the inherited IRA or retirement plan have to be taken out over a 10-year period. Next question is, what type of retirement accounts are affected? The answer is traditional IRAs, Roth IRAs, and employer-defined contribution plans such as 401ks, but other examples would be Section 453B and 457 type plans. I also want to point out, because most people question, Jordan, why do you have Roth IRAs included in that? I thought Roth IRAs, there was no required minimum distribution rule. Well, that's true for the Roth IRA owner. However, the required minimum distribution rules do apply to inherited Roth IRAs. Let's go to the next question. When does this new law take effect? The new law is effective for retirement accounts of decedents that die after 2019. However, the law may also have impact on retirement accounts being distributed for those who died prior to 2020. And I'm going to get into those rules in just a moment. So again, the basic rule is that if the retirement plan that you inherit is from an individual who died prior to 2020, with only certain exceptions, you're under the old rules, and you can use your life expectancy to determine the amount of the required minimum distribution. However, if the person that you received the inherited account from died after 2019, meaning right now in 2020, the new 10-year payout rule is in place. So let's go to two examples. Example number one, John dies in 2020 and has named his daughter Lisa as the beneficiary of his IRA. Had he died prior to 2020, Lisa would be able to take minimum distributions from the IRA over her lifetime, the old rule. Under Secure, Lisa must take out the entire balance within 10 years. It's pretty straightforward. Let's go to example number two. Same as above, except John died in 2015, and Lisa has been taking out the minimum distributions since that time over her life expectancy. He died prior to 2020, so the old rules apply. Because John died prior to 20, Lisa isn't impacted by the new law, and as I just mentioned, can continue taking the distributions over her life expectancy. However, and this is the exception here, when Lisa dies, the new beneficiary will only have 10 years to take out the remainder. And that's because Lisa dies after 2019, so the beneficiary of what's remaining in that account will be subject to the new 10-year distribution rule. Let's move on. How do required minimum distributions work under the 10-year payout rule? Well, actually, there's no real required minimum distribution except in the 10th year. And that's because the law just says that the account has to be emptied out within 10 years of the date of death, or a little after. We'll get to that in just a moment. So you don't have to take anything from that account in years 1 through 9. And if you do take it out, you may want to do some tax planning. So you're taking distributions out in a year where your tax rate is relatively low. So a little tax planning can be done in years 1 through 9. However, in year 10, there is sort of a required minimum distribution because the balance of the account has to be emptied out by the end of the 10th year. So when does this 10-year period start? It actually starts with the year that follows the year of death. So in actuality, the payout period is actually 11 years, the year of death plus 10 years. So for example, if John in my prior examples dies in 2020, his IRA must fully be distributed by the end of the year 2030. So what happens if the account balance is not fully distributed by the end of the 10th year? If you recall, there's a rule that's still on the books that says that if you don't take out the required distribution amount, if there's a deficiency, there's a 50% penalty on that deficiency. So any amount that's left over in the account after the conclusion of the 10th year and any subsequent year is subject to a 50% penalty. So it's very important to abide by that 10-year payout rule and get everything paid out by the end of that 10th year. So the next question is, are all beneficiaries subject to the new 10-year payout rule? And I said on the first slide that there are some exceptions, and there are 4 exceptions. The first exception to the 10-year rule is the surviving spouse. So when a surviving spouse inherits an IRA or retirement plan, he or she can continue to use their life expectancy. And the surviving spouse, as we know, has the option of also rolling the inherited IRA or retirement plan into their own IRA and take it out over their life expectancy. The second exception to the 10-year distribution rule is a beneficiary who is less than 10 years younger than the account owner. So this might be a sibling or a very good friend that's less than 10 years younger than the account owner. These beneficiaries can continue to use their life expectancy and don't have to use the 10-year payout rule. The third exception is a chronically ill or totally disabled individual, and it's very important that this condition has to exist as of the date of the death of the account owner. So if you're an individual that is otherwise subject to the 10-year payout rule, and in year 4, for example, you become totally disabled, you can't switch at that time to the life expectancy rules because that is determinative as of the date of the account owner and you were healthy as of that date. The fourth exception to the 10-year payout rule is if the account is left to a minor child of the account owner. Now I stress child, not grandchild. And that individual can use, that minor child can use a life expectancy payout rule until the age of majority. And at that point, the 10-year rule kicks in. So if an 8-year-old inherits your IRA, for the next 10 years, they can use the life expectancy rules. But once they turn 18 or 21, depending on the age of majority in the state where that beneficiary lives, the 10-year rule would kick in and they would have 10 years from that point to take the entire account balance out. A lot of people have set up their IRAs and retirement plans and left them to a trust, making the trust the beneficiary of their IRA or account balance. And these are known as see-through trusts, or in some cases, accumulation trusts, and many times are used as an asset protection vehicle and named as IRA beneficiaries. The problem is that these IRA trusts may no longer make sense in light of the 10-year rule for various reasons and have some unintended distribution and tax consequences, which we just don't have the time to get into right now. So my advice is that if you have an existing plan where your IRA or employer plan is being left to a trust, go back and speak with your estate planning attorney or CPA to make sure that that is still the best vehicle in this situation. So what is the tax impact of the new 10-year payout rule? And that really depends. And I have 3 situations here. The first is for small accounts. In this situation, there's probably not going to be a big impact since most beneficiaries generally wipe out their inherited IRA, that inherited IRA account within a few years anyway, and anything that they take out probably won't add a very large tax burden when added to the rest of their income for the year. So we're not too concerned about small account balances. Also, for accounts left to surviving spouses, we're not too worried because remember, spouses aren't subject to the 10-year payout rule. So there's no real impact to the surviving spouse. So if the spouse that died was fairly young and leaves his or her IRA to a surviving spouse that is also fairly young and fairly healthy, he or she has the rest of their life plus 10 years to empty out that retirement account. So we're not too worried when the surviving spouse is named as the beneficiary. The problem comes up when there are large retirement accounts that are left to other than the surviving spouse or one of the other accepted types of beneficiaries. In this case, if it's left to a son or to a daughter or to a friend or to a cousin that's not less than 10 years younger than the account owner, they may be inheriting $3, $4, $5 million, which now has to be taken out over a 10-year period, and that can add some significant tax burden, both federal and state, if the state taxes IRA distributions for that beneficiary and cause significant tax issues for them. And this is where the planning really needs to be focused, because we're looking at the income tax impact on the beneficiary that is inheriting this large IRA and must take it out over a 10-year period. So the question becomes, are there any workarounds to either replicate the stretch IRA that we used to have or reduce the taxes along the way? And I have about 7 ideas that I'd like to share with you. The first, of course, is if there's a surviving spouse that has a long life expectancy, make him or her the beneficiary, because you'll get the stretch IRA for their life plus the 10 years, as I previously mentioned. The second option is change beneficiaries and possibly spread the accounts over multiple beneficiaries. So if you were going to leave the account to a beneficiary that was subject to the 10-year rule, but you had another beneficiary of your estate that was less than 10 years younger than you, maybe switch some of that IRA over to that person who can continue using life expectancy, and to this other beneficiary that you just took something away from, give them another asset, or give them other assets from your estate to make up for it. So you want to use the surviving spouse and those beneficiaries that are less than 10 years younger or maybe a minor child as much as possible up front, and then sort of fill in from there. A third planning idea would be to leave your IRA or a portion of your IRA to charity. Why? Because charities are tax exempt. They don't pay any taxes. So when you leave your IRA or retirement plan or a portion, you don't have to leave the entire thing, to your favorite charity, they get those assets tax free, as opposed to an individual beneficiary, who of course is going to pay tax on the distributions from those accounts. Leave your IRA to a charitable remainder trust. Now, we don't have a lot of time to go into what a charitable remainder trust is, but basically, if you leave your IRA, as an example, to a charitable remainder trust, the charitable remainder trust is tax exempt, so it doesn't pay any taxes, and you've named beneficiaries of that charitable trust who will receive an annual annuity from the trust for the rest of their lives. And at the end of their life, at the end of their lives, and if you have more than one person, at the death of the second beneficiary, whatever's left in the charitable remainder trust goes to the charity or charities that you have named in the document. But in the meantime, what you have done is you've replicated the stretch IRA concept, because after you leave the funds to the charitable remainder trust, the annuity is paid out of the charitable remainder trust, and the charitable remainder trust distribution is not subject to a 10-year payout rule. That was done away with once you took the money out of the IRA and put it into the charitable remainder trust. If the account owner or IRA owner is fairly young, or even if they're not so young and are taking required minimum distributions, one consideration is to accelerate those distributions and use the after-tax funds to purchase a life insurance policy on the account owner within a life insurance trust. So at the insured's death, the trust will get the insurance proceeds, which can be paid out over the beneficiary's lifetime. Again, duplicating the stretch IRA concept, but the life insurance is paid to the life insurance trust, and the life insurance trust pays an annuity or makes annual payments to the beneficiaries of that trust, and like the charitable remainder trust, would not be subject to the 10-year payout rule. So again, we're trying to duplicate the stretch IRA concept with other vehicles. If the IRA beneficiaries are in a high tax bracket, let's say you're leaving your IRA to your son or daughter who's a neurosurgeon and well into the 37% top tax bracket, consider purchasing life insurance on the IRA account owner, again, in a life insurance trust, in the amount equal to what you perceive to be the income taxes that they would be paying on the distribution. Let me give you an example. Let's say you have a $1 million IRA that you're leaving to your son or daughter who's in the 40% combined federal and state tax bracket. So the tax, when they take all the distribution of the $1 million out, would be 40% or $400,000. Purchase a life insurance policy on yourself in the amount of $400,000 in a life insurance trust payable to that beneficiary at your death. So the bottom line is your son or daughter will inherit the $1 million IRA and have the $400,000 estate tax-free and income tax-free to pay the taxes on the $1 million. So it's creating liquidity for the beneficiary. The final thought that I have is consider converting your traditional IRA to a Roth IRA, especially if the IRA account owner is in a much lower bracket than the beneficiary. This way, the account owner pays the income tax up front when they convert from the traditional to the Roth IRA, and then the Roth IRA stays in place for the rest of the account owner's life. And when the beneficiary, son, daughter, niece, nephew, whomever, grandchild, inherits the Roth IRA, yes, there is a required minimum distribution, but all those distributions are tax-free because they're coming out of a Roth account, not a traditional IRA account or employer retirement account. These are just some of the rules and some of the planning ideas that can be utilized in light of the changes made by the Secure Act. If you have any questions or would like to discuss planning around these new inherited IRA rules, please be sure to contact a member of Belfin Lyons and Schumann. We'd be happy to meet with you and help you with your planning. In the meantime, stay safe and have a great day.